Ladies and gentlemen, this is William Keat, carrying on with this series, The Essentials of the British Constitution, which we're basing on this document, The Occulted Powers of the British Constitution. I think we're on to Part 6. This is it, the validity of the 1215 Great Charter. So this is sort of a little bit of a continuation from the previous part, because the previous part was starting to get into the Great Charter and what it was containing. And we were talking about the kind of law that actually is contained within the Magna Carta, which of course is legitimacy, the law of the land, which is what we actually call common law, and we were just sort of clarifying that issue there. Now we're going to go into other aspects of the Great Charter and why it's absolutely valid. We'll just get straight into that. So let's not waste any more time. Here we go. There are a number of much repeated arguments that attempt to invalidate the 1215 Magna Carta, but all of them can be dismissed once one knows and understands the historical detail and context at the time. One of these is the argument that the Great Charter was signed under duress, and those that make this argument do so without realising that King John was, quite rightly, under duress. They forget the important fact that the king was already bound by his coronation oath and was under contract with the people. Under the already established common law of the late Saxon kings, England functioned as a limited monarchy, in which the monarch, far from being considered absolute in power, was in fact regarded merely as first among his equals, his peers, the titled barons, who had the right to try him if he ignored his obligations and contravened his duties. So that is a really important understanding and context of this, which is that the Constitution had already been in existence. One of the important aspects of the Constitution is the coronation oath that had already existed, and the king was already bound under the coronation oath. He'd already taken a promise in perpetuity to the nation that he was going to govern according to these principles and place these limitations on himself, if you like, as a monarch. Meaning, of course, that the monarchy is fundamentally limited. Yeah, and that's a really important understanding. We know that that's the case, that the monarch is a limited monarchy. Unlike later, where that got a bit distorted, that understanding, and we sort of took on this idea that it was about the divine right of kings. Absolutely not the case. Not true at all. So constitutionally, this was a limited position. Really important. Now, the other thing, just to mention there, is that I said in that sentence, they forget the important fact that the king was already bound by the coronation oath and was under contract with the people. Okay, now it's important to say at this point that it's not really a contract in the sense that the people were a bound party to that contract, because you can't get the people to sign a contract, either individually, everybody in the country, nor can you get the people as an entity. It's just an abstraction of the mind. You can't have a group signing a contract. It doesn't. That's not really what it is. But what I mean by that is that the people were a beneficiary to that contract. They weren't a bound party to it. They weren't bound by it or compelled by it in any sense. But they were a beneficiary to that. So really, in a way, what we mean by that contract is that it was a one-sided contract on the part of the monarch to promise these things. Yeah. So that's the only thing I need to say about that. But let's just put this into academic context by quoting from David Hume. Here he is, David Hume's History of England. Have a listen to this one. The king, so far from being invested with arbitrary power, was only considered as the first among the citizens. His authority depended more upon his personal qualities than on his station. He was even so far on a level with the people that a stated price was fixed for his head, and a legal fine was levied upon his murderer, which, though proportionate to his station and superior to that paid for the life of a subject, was a sensible mark of his subordination to the community. Okay, so you couldn't get clearer than that. Yeah, that's just saying quite clearly that actually the king was almost on a level with the people. Yeah, and that's how he was regarded, especially at the time, much more so. Yeah. So carrying on, it is important too to keep in mind the crimes of the king. He was violent, and he had allowed himself or his most senior aides and soldiers to commit rape and other acts of violence. He had also made families destitute and taken land from people. These were crimes of a tyrant, and the barons were holding John to account according to his oath and responsibilities as the most senior public servant in the land. Just re-emphasising that point there, yeah? It is also important to understand the true nature of the state of aristocracy in England under common law. This was not merely a system of privilege for some lording it over the peasants, as is often assumed. This system of aristocracy was there to ensure that everyone in the land, regardless of their social status, when before a jury, was judged by those who were in the same social context as themselves, their peers. And as already mentioned, this was also true of the king. So the king had his peers as well. Yeah. It was essential under this common law system that the monarch, if he stepped out of line and was also able to be judged by his peers. Furthermore, to be a just system, it was also crucial for those peers that were to judge the monarch to be of the same social standing. Hence, the king's peers were the barons, the peers of the realm. Similarly, those of lower status, so the villeins, cotters, churls, and the like, must be judged, if in court, by their peers, their social equals. Under the authentic common law system of the time, it was essential that every man and woman in the land, if brought before a court, must have the opportunity to be judged by those who experience the same temptations and pressures in life. They would also have access to the earlier mentioned private prosecution, which I can go into separately, but that's just really important to understand that's really what the aristocracy was about. It was a layer in society where the stations of these people, their station, right, it's their level of responsibility, you know, whether you were a knight or, you know, or whatever, something else, that you were judged, if ever before a court, by the sort of people, the appropriate people around you who understood, you know, your pressures and your temptations and your context in life. That was really important, really for you, so that, you know, you weren't judged by somebody who really had absolutely no idea about what your life was really about. Yeah, there is actually some sense in that, I think. So, continuing. Whether or not an unexpected benefit or an intention is not clear, but this was nevertheless the true nature of aristocracy under the genuine common law. And to return to the matter of King John, the barons were essentially convening a common law court, in which they were the judges, performing their sworn duty to try the king for his crimes. They were rightly holding him to account. So that's what the 1250, the Runnymede event was really about, yeah? So I think I've made that clear, that, you know, that's in a sense, that's what it was. It was a trial by jury, you know, and it was a chance to get out of John at the time a reaffirmation or a clear re-expression of his promises, and having that signed or sealed rather, which is what kings would do. Any member of the aristocracy would seal with their coat of arms. They would that's how they would sign it, essentially. That's how it was done, and it was getting him to redo that because clearly things had gone very wrong, and that's quite a reasonable thing. To understand that and characterize it like that you can see how that is very different from what a lot of people are claiming. So carrying on, this is the next common argument. The second commonly presented argument by detractors is the claim that the Pope invalidated the 1215 Magna Carta. The Pope was not party to the formal arrangement of the head of state of England. He was an outsider who had no right to step in and involve himself in the affairs of a foreign nation. King John, for the reason already mentioned, was bound under his coronation oath and had no right to appeal to the Pope for assistance. Therefore, any subsequent decree put out by the Pope had no validity and authority. The supremacy of the 1215 Magna Carta remained. Right, so actually for very similar reasons. This is not to do with... These affairs of England were not to do with a foreigner. And the Pope had no business to be interfering in these issues to do with the fact that our own monarch was stepping out of line and acting criminally. Because that's what was happening. Right. So same thing really, same argument. Carrying on. Finally, our modern day Parliament and the government more broadly makes the claim that the later rewritten legislated forms of Magna Carta produced in, among others, 1225 and 1297 can somehow overwrite or supersede the 1215 original. The Great Charter was not legislation, but a promise by the head of state to the people in perpetuity. The only way an uncomfortable establishment could attempt to extricate itself from the limitations in which it is bound would be to pretend to others or even themselves that their legislative powers give them that authority to alter those principles of the original Magna Carta. Our history is littered with veiled attempts by the legislature, largely through confusion and obfuscation, to throw off the shackles of this constitutional framework in which it sits. Although they can't legitimately do so, it might be seen by those with a controlling mindset as imperative that they try to obscure and bury the confirmation of the people's sovereignty contained within the 1215 Magna Carta's Articles of Common Law. For the citizens to have authority over government that was successfully established by the Charter, coupled with the perpetual nature of it, establishing these government limitations in perpetuity on all subsequent monarchs and administrations, was a bombshell to all future collectivist or statist thinkers. You know, I mean, it couldn't be clearer. You know, this was basically, it was an absolute bombshell that this promise was re-established and expressed clearly like this in written form. You know, so this is this business about, you know, do we have a written constitution? Well, actually, yeah, we do. Okay, because that promise really is our constitution. It's the binding framework over government, right? It can't be any clearer, and it's absolutely written, right? And what the sort of wishful thinking from the legislature is that, well, we can actually use our legal powers to kind of change that in law. Well, no, you can't, actually, because the 1215 Magna Carta isn't legislation. It's above that. You know, it's the promise of the head of state that I am going to operate my government within this binding framework. Yeah, and the legislative powers, and we've talked about this already, in the legislature, does not have the power to allow government to write itself into a higher position within that framework. I've said that loads of times, and yet it's one of the most prevalent misunderstandings, not only in the establishment but generally even by campaigners. So can't make that any clearer, really. Okay, and the attempt to reframe, if you like, that promise within legislation in subsequent versions. So there was another one actually in 1216 or 17, I can't remember, almost a year after the 1215. And then there was the 1225, and then the 1297 is the Edward I Confirmatio Cartarum, which is on the statute books currently. Now, what they did do in those versions of Magna Carta, in a sense, what they were actually doing, I suppose, at the time, was each king was creating a sort of manifesto, if you like, about showing the nation how they were going to govern within the limitations that were placed upon them. It was like a declaration, if you like, of how they were going to do that. But remember that the king only has the power to create statute and nothing higher than that. So the only way that he could do that would be in some kind of a statute that would agree with the principles of the 1215 Magna Carta, right? But it's not the same thing as the 1215 Magna Carta. It isn't legislation, so you can't use that legislation to alter or repeal anything in the 1215, because the 1215 isn't legislation. It's like something completely outside that, yeah? But what you can do is you can frame the same principles. You can put the same principles in, then paraphrase them and re-express them, and that's exactly what they did. But that's the real characterization of how it really was operating back then. So carrying on, it's just one more paragraph actually. The attempts to weaken common law trial by jury in those early years marked only the beginning of an ongoing tussle between the state and the people as to who should be the final arbiter of law. Okay, so there it is. So a little bit more about the 1215 Magna Carta and what it is, but it's the binding promise. Reaffirmed. It's the promise was already in place before that, but this was a new written version of that promise, of the contract, if you like, to the people that was in place. So that's why I and others like Ken Dudney and at Democracy Defined often refer to the 1215 Magna Carta as our constitution. I mean, the constitution already existed before that, but this is the most recent framing of it, if you like, or the most recent expression of it in pure form, which is why I always really refer to the 1215 as the Constitution, and it's written. Last time I looked, it's written. So there we are. Okay, I hope that was useful. Next section is the dangers of suffrage, majority, and consensus. So we need to get into that, which is what's happened more recently and in the last 300 years or so. Hope you found that useful. Cheers for now.